We are continuing our conversation on the United States and LGBTQIA plus history and laws. Today we talk about discrimination protections. Now, prior to 2020, whether the Civil Rights Act gave federal protection against employment discrimination to the class of LGBTQIA people was in dispute. Individual states since 1973 acted on their own accord to extend employment discrimination protections to explicitly cover LGBTQIA plus employees. Before 2020, 21 states had included LGBTQIA plus individuals as a protected class against employment discrimination, while other states offered some but less extensive protections in their laws. Over 225 jurisdictions, including the District of Columbia, as of 2016, and 22 states, as of 2018, feature legislation that prohibit discrimination based on gender identity in their employment, housing, and/or public accommodations. There is no federal law designating transgender as a protected class or specifically requiring equal treatment for transgender people. Some versions of the Employment Non-Discrimination Act introduced in the U.S. Congress have included protections against discrimination for transgender people, but as of 2021, no version of ENDA has passed. Since 1994, members of the Democratic Party in the U.S. Congress have introduced some form of the Employment Non-Discrimination Act, ENDA, in nearly every two-year term, which would have amended the Civil Rights Act to include both sexual orientation and gender identity as protected classes under Title 22. It faced opposition over whether transgender Americans would be protected. An expanded version of ENDA, which included both sexual orientation and changed sex to gender identity in its protections, passed the United States Senate in 2013, but did not advance in the House. In 1995, President Bill Clinton's Executive Order 12968, establishing criteria for the issuance of security clearances, included sexual orientation for the first time in its non-discrimination language. It says the United States government does not discriminate based on race, color, religion, sex, national origin, disability, or sexual orientation in granting access to classified information. It also said that no inference about suitability for access to classified information may be raised solely on the basis of the sexual orientation of the employee. In 1998, Clinton's Executive Order 13087 prohibited discrimination based on sexual orientation in the competitive service of the federal civilian workforce. It applied to the large majority of federal employees, but not to the accepted services such as the military. In October 2009, Congress passed the Matthew Shepard Act, which expanded the definition of hate crimes to include gender, sexual orientation, gender identity, and disability. At the start of 2010, the Obama administration included gender identity among the classes protected against discrimination under the authority of the Equal Employment Opportunity Commission, the EEOC. That same year, Obama issued an executive order to the Department of Health and Human Services to draft new rules for all hospitals accepting Medicare and Medicaid funds. They would require facilities to grant visitation and medical decision-making rights to gay and lesbian partners, as well as designees of others such as widows and widowers. In 2012, the EEOC ruled in Macy versus Holder that discrimination on the basis of gender identity is a form of sex stereotyping, and thus prohibited in employment as a form of discrimination on the basis of sex under Title 22 of the Civil Rights Act of 1964. They had used past case law and its evaluation of discrimination cases brought before it to establish that LGBTQIA plus discrimination is unlawful under the context of the Civil Rights Act. Also, in 2012, the Department of Housing and Urban Development's Office for Fair Housing and Equal Opportunity issued a regulation called Equal Access to prohibit LGBTQIA plus discrimination in federally assisted housing programs. July 21st, 2014, President Obama signed Executive Order 13672, adding gender identity to the categories protected against discrimination in hiring in the federal civilian workforce, and both sexual orientation and gender identity to the categories protected against discrimination in hiring and employment on the part of federal government contractors and subcontractors. In 2015, the EEOC ruled in Baldwin versus Fox that discrimination on the basis of sexual orientation is prohibited in employment under Title 22 on the exact same basis as in Macy. The Equality Act has been introduced in 1974 and each following term, most recently 2021. The Equality Act of 1974 sought to amend the Civil Rights Act of 1964 to include prohibition of discrimination on the basis of sex, sexual orientation, and marital status in federally assisted programs, housing sales, rentals, financing, and brokerage services. The bill authorized civil actions by the Attorney General of the United States in cases of discrimination on account of sex, sexual orientation, or marital status in public facilities and public education. It did not proceed to a vote in the full United States House of Representatives. Most recently, the Equality Act, if passed, would amend the Civil Rights Act of 1964 to prohibit discrimination on the basis of sex, sexual orientation, and gender identity in employment, housing, public accommodations, education, federally funded programs, credit, and jury services. June 2020. It was held that Title 22 of the Civil Rights Act of 1964 extends protections to individuals who are transgender in employment. This is based on discrimination on the grounds of transgender status is a form of discrimination based on sex. Prior to the rulings that Title 22 protections covered transgender status, 4 states, Alaska, Arizona, Wisconsin, and Missouri, had not enacted specific protections based on transgender status in any employment, and 22 states had extended protections in public employment only. June 12, 2020, the Trump administration issued a new rule stating that sexual orientation and gender identity were not covered under the anti-discrimination protections of the Affordable Care Act, but this was reversed by the Biden administration, restoring the Obama-era policy. As of 2020, 29 states had not outlawed anti-LGBTQIA plus discrimination, with members of the LGBTQIA plus community being given little protection at a national level, and 2/3 of LGBTQIA plus Americans in the United States reported facing or having experienced discrimination in their personal lives. As of December 2023, 46 states, the District of Columbia, Puerto Rico, the U.S. Virgin Islands, and the Commonwealth of Northern Mariana Islands have statutes criminalizing various types of bias-motivated violence or intimidation. Each of these statutes covers bias on the basis of race, religion, and ethnicity. 34 cover disability, 34 cover sexual orientation, 28 cover gender, 13 cover age, 23 cover gender identity, and 5 cover political affiliation. In 2020's Bostock versus Clayton County, the Supreme Court decided that Title 22 of the Civil Rights Act of 1964 protects employees against discrimination on the basis of sexual orientation or gender identity. The ruling has been hailed as one of the most important legal decisions regarding LGBTQIA plus rights in the United States, along with Lawrence versus Texas in 2003 and Obergefell versus Hodges in 2015. This effectively means that in the United States, no employer can fire an employee on the basis of sexual orientation or gender identity. January 2021. President Joseph Biden issued Executive Order 13988, requiring the federal government to interpret Title 22 as protecting against discrimination on the basis of sexual orientation or gender identity. The Executive Order on preventing and combating discrimination on the basis of gender identity or sexual orientation also required that federal agencies include discrimination on the basis of sexuality and gender if a federal anti-discrimination statute covers sex discrimination. April 2024, the EEOC amended its rules defining workplace harassment to include harassment of LGBTQIA plus people, including transgender people, over pronoun preference or using the bathroom aligned with their gender. They do know that the T in LGBTQIA plus stands for transgender, right? 24 states, the District of Columbia, Puerto Rico, Guam, and over 140 cities and counties have enacted bans on discrimination based on sexual orientation and or sexual identity. Additionally, some states have laws or regulations that ban discrimination based on gender identity and or sexual orientation in public employment only. In 2025, the 47th President Trump signed an executive order titled Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. The order withdraws federal recognition for transgender people. It requires a federal department to recognize gender as immutable, male, female, binary, determined by biological sex assigned at conception. Conception. Do you see the space between my two nails? That is what you look like at conception. There's no gender. Okay. But they say it can't be changed. Okay. It also ceases all funding for gender-affirming care and the promotion of gender ideology. ceases allowing gender self-identification on federal documents such as passports, and prohibits transgender people from using single-sex federally funded facilities congruent with their gender. It also asked the Attorney General to reevaluate the application of Bostock versus Clayton County in 2020 as to not provide Title 22 protection based on gender identity in federal activities, arguing that it was misapplied. I mean, what can the Attorney General do? The Supreme Court has already decided. Yeah. Anyways. The EEOC sought to reverse its April 2024 rule change to comply with this new executive order, but Trump had fired the EEOC's 2 Democratic commissioners in January of 2025, and the EEOC lacked a quorum to do so. August 2024, the state of Texas and the Heritage Foundation filed a lawsuit challenging the rules on the basis that they forced businesses to recognize transgender people and override state mandates on respecting their stance on biological sexes. Federal District Judge Matthew J. Kaczmarek of the Northern District of Texas ruled in favor of the state in May of 2025, saying that the EEOC exceeded its statutory authority in creating the new rules. Per Kaczmarek, Bostock did not cover aspects like preferred gender, bathroom use, or dress codes. A poll conducted by Quinnipiac University in April of 2019 found that 92% of American voters believed that employers should not be allowed to fire someone based on their sexual orientation or sexual identity, while only 6% believed that employers should be able to do so.